I'm just doing intro. I'll just do intros now. Welcome back to Gossip About Prejudice. Today is office hours, so we are acutely aware that many of you have been watching our LTBE clips, and right now there's not much LTBE actually on our podcast. So today we are doing like 15 LTBE questions, and then we will be clipping them and putting them on social media. But if you guys want a more in-depth explanation, we'll be not only going over the correct answer here, but we'll also be going over like why all the other answers are wrong, if the answers are interesting. Lindsay, how are you feeling?
As much context as you could possibly desire.
Yes.
I'm a little nervous. I'm a little nervous. I know I'm not going to do well, but you know what? It's always fun anyways.
We're really looking into ways to expand the format. We've thought about LSAT questions. Some of our team here have very excellently suggested that. I'm a little leery on LSAT questions personally because they're much longer and they're not necessarily law related, and they don't hinge on knowledge. They hinge on like verbal wordplay trickery bullshit, and so they're much less fun to listen to because you've got to use like 100% of your brain, and anyways, we're thinking about expanding the format. If you have suggestions about what you want answered, what topics you want us to cover, please message us on socials. Leave a comment on the podcast, rate, review if you love what we're doing, if we're helping you study for the bar this coming July. Whoop, whoop. Other than that, we can just jump right into it after a thank you to our sponsor, Quimby Bar Prep.
Thank you so much, Quimby.
Quimby's a real one. They have given us an account where we get all these questions, real, and some are real and some are simulated and written by Quimby's team. It's been a ton of fun for us to go over these with everybody. Lindsay, are you ready for your first question?
I suppose I'm ready. Let's dive into it.
Let's go into it. A restaurateur married her husband E in year 1. Soon after, the restaurateur became pregnant with the couple's child while giving birth to F. The restaurateur exclaimed, "You shouldn't have done this to me, G." No, seriously, letter G.
Letter G, okay.
G was a waiter in one of the restaurateur's eateries. Due to then undiagnosed paranoid delusions, the restaurateur believed she had carried on a sexual affair with G, who was thus F's natural father. In truth, E was the only person whom the restaurateur had ever had a sexual relationship with. The following year, the restaurateur executed a will providing that, quote, "I leave the sum of $500,000 to my beloved child, F. I leave nothing to my husband, E, because he did nothing to help bring my dear F into this world. I leave the residue of my estate to G, my lover and paramour, father of my beloved F." Shortly after, the restaurateur died. E challenged the entire will on the grounds that it was the product of an insane delusion. Paternity testing, expert testimony, and other uncontroverted evidence established the foregoing facts at trial. Which provision of the restaurateur's will, if either, is E likely to succeed in invalidating?
Goodness gracious almighty. What a doozy.
Are you ready?
Give me my options, please.
Okay, option A, only the $500,000 gift to F. B, only the gift to the residue to G. C, both the $500,000 gift to F and the gift of the residue to G. D, neither the $500,000 gift or the residue to G.
Ooh, this is interesting. I got no heckin' clue, but I'm really feeling attracted to B here. I think that if the court took a look at this, they wouldn't, because there's nothing in claim here about the daughter. That's not, or F rather. I'm assuming F is a daughter. But, so no, I think it's B.
Think it's B?
I'm locking it in. Let's go for it.
Locking in B, only the gift of the residue to G, with 69% of students answering correctly. B is the answer. A will is void to the extent it arises from a tester's insane delusion.
Wow.
An insane delusion means that the testator, blah, 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 against all rational evidence espouses a false belief. So my old professor used to put it this way. You have to know what you have and who you're giving it to. Rationality is a really high bar to clear when it comes to estates, because there's public policy and not wanting there to be too much instability when overturning.
Yeah, you don't want it to be easy at all to change a will posthumously.
Because if the person who left it isn't around anymore, you have to do your best to let their last wishes stand. It's just really important. It's respect for the dead. So like, if you can be like, I leave my gold encrusted diamonds to my neighbor, and you own gold encrusted diamonds and you have a neighbor, all good.
There you go.
But if you say, I leave my gold encrusted diamonds to my nephew Batman, not good, because Batman is an insane delusion. You know what you have, but you clearly don't know who or what you're giving it to. And that's what happened here. The false belief must materially affect or influence at least one disposition in the will. Only those provisions affected by the delusion are void, unless perhaps the delusion influenced the will at large, though that is a question for litigation.
Okay, well, there you go, folks. Goodness, what a doozy. Oh my goodness.
The gift to F, though, will likely stand.
Yeah, because that has nothing to do with the fathership of whoever F is.
Yeah, because she left it to F because the restaurateur believed F was her child, which she is.
That's such a crazy delusion. Thinking that the parent of your child is someone other than who they are.
Yep. Hence, no false belief, irrational or otherwise, influence the gift, and therefore the gift will likely stand. So it's a really interesting fact pattern here. I just really wanted to jump into it. We're going to put references here. There's this case law is on point from a case called Kingdon v. Cybrant, which was in the Wisconsin second edition reporter. And Robertson v. Robertson, so a case in Oklahoma from 1948. Trust in estates is a beast that I try never to touch because it's a really fractious, like you see the worst of people. You see families tear each other apart. And siblings trying to gouge their eyes out. I'm not a huge fan. Did that make sense though, Lindsay?
It did. It made sense.
Perfect.
Thank goodness it made sense.
Want to move on to your next question?
Let's go for the next one.
All right. A manufacturer sold a lawnmower to a big box retailer, which in turn sold to a customer. The customer used the lawnmower without incident for several months to mow the lawn at his home. When the customer moved to a condominium with no lawn, he sold the lawnmower to another homeowner via a resale website. The homeowner was impressed that the mower looked to be in brand new condition when he purchased it from the customer. Approximately 6 months after purchasing the lawnmower, the homeowner was injured when a spring in the motor came loose and struck his leg. The homeowner sued the manufacturer, retailer, and customer for his injuries, claiming that the lawnmower was defectively designed. Who may be held strictly liable for the defective lawnmower?
Ooh, I got no clue. But
Your options are A, only the manufacturer, B, only the manufacturer and the retailer, C, only the retailer and the customer, or D, the manufacturer, the retailer, and the customer, all of them.
I have zero legal basis on which to jump off here. So I'm just going with straight logic. And my logic tells me that it's going to be just A, the manufacturer, because it's no one else's fault if it was built faulty. Like, that's not the fault of the guy who sold it to him.
So only the manufacturer?
I think I'm locking in A, only the manufacturer.
With A, with 25% of students answering, that is incorrect.
Ah, damn it.
Correct answer is B, only the manufacturer and the retailer, with 70% of students answering correctly.
Wow.
In general, strict products liability is imposed if 1, the actor was a commercial supplier of defective product, 2, the product was defective when it left the actor's control, 3, there was no significant change in the product's condition, because remember, it looked brand new, and 4, the defect actually had proximately caused the injury. Though that's more of a general liability rule than a products liability rule, but like that's the fourth token. Here, the lawnmower was brand new, and the first customer to purchase it, he had no control over how it was purchased or manufactured or distributed, and so you go upstream to the source.
Okay.
Though I will say the retailer here probably has a strong cause to cross-claim against the manufacturer and say, look, we just sold the product. We didn't know.
We just moved a box.
Yeah, exactly. So the real-life answer would probably be you just go straight for the retailer and the manufacturer, and then the retailer would find a way out of the lawsuit after not too much time.
I see.
Makes sense?
It does. That's cool. There you go, folks. You guys did a lot better than me on that one.
Yeah. The big box retailer and are both in the business of selling lawnmowers, so they are both legally commercial suppliers. I just wanted to clarify that.
I see. Okay.
Yeah, the customer is not.
Right.
Yeah, he doesn't sell lawnmowers. Yeah, exactly.
Consumer.
A police arrested a suspect in a string of robberies. Before the defendant was formally charged, the police placed him in a lineup with 5 individuals of some similar appearance and asked a witness if she could identify the person who robbed her. After the suspect was arraigned, the police invited another witness to look at a photo array which contained a picture of the suspect and a picture of the other individuals of similar appearance. At which event, if any, was the suspect entitled to the assistance of counsel?
Oh. I don't know.
Your options are A, both the lineup and the photo, B, only the lineup, C, only the photo array, and D, neither the lineup or the photo.
I think it's gonna be neither, but I got no hecking clue as to why. I've got zero justification to share.
Locking in D with 68% of students answering D is correct. The Sixth Amendment right to counsel attaches, remember we talked about this earlier, at every critical stage of the pretrial proceedings. Bond hearings, whether or not you sit in jail, is not a critical stage. And here, whether or not you are recognized or whether or not you are in a photo lineup really has no bearing on the outcome. It's just fact-finding, which is the role of police.
If you had a lawyer there with you, what would they do anyways?
Yes.
Say, you can't look at my client.
A witness looking at a photo array is not considered a critical stage, meaning that a defendant is not entitled to the assistance of counsel, even if the photo array procedure occurs after the defendant has been formally charged. Because investigations can be ongoing after you are charged.
For sure.
Yeah.
Cool. All right, 2 for 3 so far this episode.
Nice. A criminal defendant was charged with 2 felonies: aggravated assault and assault with a deadly weapon arising out of the same incident. Go off, King. The relevant jurisdiction... I learned my lesson last time. Last time with the drug dealer guy, I'm still saying it. The relevant jurisdiction defined aggravated assault as, quote, attempting to cause serious bodily injury to another, purposely, knowingly, or recklessly under the circumstances manifesting extreme indifference to the value of human life. Love that. And defined assault with a deadly weapon as, quote, attempting to cause, purposefully or knowingly, bodily injury to another person with a deadly weapon. May the defendant be convicted and punished for both offenses. Your options are A, yes, because the offense do not have identical elements. B, yes, because the statutory language does not specify that either offense is a lesser included offense of the other. C, no, because the offenses constituted a single act. And D, no, because neither offense required proof of a fact that the other offense does not.
I have no clue. I say that every time. I'm so bad.
What are you, not a lawyer?
What?
Where'd you go to law school?
Western Washington University School of Law that doesn't exist.
This is a baffling one even for me. I'm not a criminal law guy, so like.
Just based on gut feelings, I think I'm leaning towards B. And B was that they do not say that they're a lesser. I don't know, ma'am, but I'm locking in B.
With 13% of students answering B, that is incorrect. Answer A, yes, because the offenses do not have identical elements. Just like Judge Dugan, from one act, she was charged with 2 federal offenses, but they don't have identical elements.
Right.
So you can be charged with multiple crimes from one single nexus of facts. The double jeopardy clause prevents a defendant from being convicted or punished twice for the same offense, but 2 offenses are defined as the same if they consist of the same elements or if one offense consists of all the elements of the other plus additional.
I see.
Here, aggravated assault requires the defendant to act under circumstances manifesting extreme indifference. And an element that is absent from the crime of assault with a deadly weapon. So because of that,
they're different.
Punished for both. Yeah, you can. It's different. B is incorrect. A state do not need to specify that the offense is a lesser included offense of another. Just think back to common sense. If every single statute of possible crimes at the state and federal level had to specify whether it was a nesting doll of another,
that would never work.
That would break the entire system.
Yeah,
so
no.
always think about, if you don't know the law, think about the implications for the justice system for the other laws that you know.
I will try that next time. We're 2 for 4.
All right, okay, here we go. A witness possibly identified a robbery suspect in a lineup in which the suspect's appearance was distinctly different from all other individuals in the lineup. After the suspect was indicted, the suspect moved to suppress the identification on the grounds that the lineup was unnecessarily suggestive. The judge found that because the suspect's appearance was distinctly different from all the other individuals in the lineup was unnecessarily suggestive. However, the judge ruled that the identification was admissible. Which of the following findings, if any, would support the judge's ruling that the identification was admissible? Your options are: A, there are no findings that would support the judge's ruling. B, that the identification's reliability outweighs any corrupting effects of the unnecessarily suggestive procedure. C, that the unnecessarily suggestive procedure was inadvertent and not the product of deliberate law enforcement action. And D, that the unnecessarily suggestive procedure was reasonably justified under the circumstances.
I like B. Yeah, that fits. That jives in my head the most with the judge agrees, yes, it was what was the word? That the lineup was
Unnecessarily suggestive.
Yes, unnecessarily suggestive, but they still want to admit it anyways. So I'm thinking it's B. I'm going to lock it in right there.
With 44% of students answering correctly, B is the answer. The next most likely answer with 27% of students answering was A. There are no findings that would support the judge's ruling. Judges call balls and strikes. Even pretrial identifications that result from unnecessarily suggestive procedures may be admissible, but only if they are not irreparably conducive to mistaken identification. Thus, in order to be admissible, the reliability of the identification must outweigh any corrupting effect from the procedure. See Perry v. New Hampshire, which was a 2012 case. Therefore, the judge found that the identification's reliability outweighs any corrupting effect from the unnecessarily suggestive lineup.
All right.
Yeah. Well, and it's good you didn't go for the deliberate law enforcement action in answer C. Law enforcement can do things. They can argue that they do things non-deliberately that are still highly prejudicial and are thrown out of court all the time. Judges call balls and strikes. That's all they do, right? They explore questions of law, and the questions of law are what counts, decides what is and isn't a foul ball. The only finders of fact are the jury. Juries decide who's credible and what happened, and then they hand the matter back to the judge to decide what to sentence the individual for, and then there are usually sentencing guidelines at the federal and state levels. Make sense?
Yes.
All right.
3 out of 5.
3 out of 5.
Okay.
We're still moving along.
Number 6.
Number 6. An art dealer conveyed an offer through the mail to sell a painting to a collector. Oh, it's one of fucking these. On the 10th of the month, the collector received the offer and sent a return letter through regular mail rejecting the offer. On the morning of the 11th of the month, the collector changed his mind and sent a letter by overnight mail accepting the dealer's offer. On the afternoon of the 11th of the month, the dealer sent a letter to the collector revoking his offer to sell the painting. On the 12th of the month, the dealer received the collector's acceptance letter. On the 13th of the month, the collector received the dealer's revocation letter, and the dealer received the collector's rejection letter. Has the collector validly accepted the dealer's offer to sell him the painting? I was talking to you about this shit a couple of weeks ago, where I was like, "There's like fuck ass mail rules where it's like I don't even know the answer to this question. I forget because it's not something I've had to deal with in my life
because it's 2025.
Yeah, because it's 2025. Answer A, no, because the collector sent the rejection letter before he sent the acceptance letter. Answer B, no, because the dealer sent the revocation letter before he received the collector's acceptance letter. C, yes, because the dealer received the collector's acceptance letter before he received the collector's rejection letter. D, yes, because the collector sent the acceptance letter before the dealer sent the revocation letter.
I'm flying by the seat of my pants here, folks, but I don't know why I keep guessing B, but B, I like B. Yep, that's what I think it is, because he said... I changed my mind before he got an affirmative yes. And so that gives him full wherewithal to be able to, nope, B, I'm locking it in.
With 11% of students answering B, B is incorrect.
Damn it!
Answer C, yes, because the dealer received the collector's acceptance letter before he received the rejection letter.
Oh, I got the order mixed up.
An offer may be accepted at any time before an offer terminates. An offer may terminate in a variety of ways, including rejection by the offeree or revocation by the offeror. Under the mailbox rule, which I fucking hate, acceptance by mail is effective upon proper dispatch. In contrast, a rejection is not effective until it is received. Otherwise, a revocation of an offer is effectively only upon the offeree's receipt. If an offeree's mails a rejection and later, after change of heart, sends an acceptance, the mailbox rule does not apply. In that case, whichever communication the offerer receives first is effective.
I think I just had a brain aneurysm.
Yeah, you won't ever have to deal with this shit anywhere except on the bar exam. I don't know.
Good luck.
I mean, I understand why courts set up these rules because back in ye olden 18th century, this stuff happened all the fucking time. Nowadays, it's just a fucking email. It's just send an email. There's no question about when an email was sent or received.
Timestamps.
Yeah, there might be some questions about when it was read, but that issue still remains when you're dealing with fucking letters. I really don't want to dwell on this one because I didn't even realize that we had a fucking mail question. I've been dreading these questions because I forget which episode we talked about this on, but
it wasn't long ago.
Yeah, these questions sent me into a rage when I was taking contracts because my contracts professor put 4 of these questions in his final exam after we talked about this once. The whole quarter. We're on the quarter system. The whole fucking quarter we talked about this rule one time.
And there were
And
4
like
whole questions.
25% of the exam's essay questions involved this rule. Thank God for curved grading. I did really well in that class.
Nice.
Okay, let's hear.
What am I? Is that 3 for 6?
I don't
I think
know.
I'm at 50%.
Yeah, we're going for 15 questions here, so we'll be in this for a while. In satisfaction of a debt it owed, a corporation assigned its right to receive payment from its customers to a lender. In exchange for the assignment, the lender discharged the corporation's debt. 2 weeks after the assignment, the corporation received a boost in capital after it signed a lucrative new contract. The corporation wanted to use the capital instead of its accounts to satisfy the debt it owed to the lender. The lender had not yet attempted to collect any amounts owed from the corporation's customers. May the corporation revoke its agreement? Your options are A, yes, because the lender has not yet relied on its right to receive payment from the corporation's customers. B, yes, because the assignment offered in satisfaction of a debt is revocable. C, no, because the assignment was for value. D, no, because all assignments are irrevocable.
This is one key thing that I simply don't know, and I can't really logic my way out of this.
I think you can.
You think I can?
I disagree with that.
What?
Think this through. So what would happen? Who benefited? Tell me, walk me through who benefited and why from this exchange.
Well, so the lender is given an opportunity to recoup their investment over time, and then the business is able to kind of shove that debt off and delay it. So the business
Delay it?
Well, not delay it. You know, like
You mean voided entirely?
no, I don't mean voided entirely.
Because it was voided entirely. That was their exchange.
They wanted to void entirely that agreement at the end.
Yes, but what was the value of that transaction? What changed hands?
What changed hands?
So
Nothing changed hands.
Well, what was the consideration is what I'm asking. So the corporation got all its debts forgiven.
Okay. Yep.
And then they assigned their what's called their accounts receivable to be
the
collected by a
lender.
third party.
All right.
So who has benefited now that they want to turn around and void this agreement?
Well, the business themselves have benefited.
Yes.
And now they want to turn around and void it.
So
Is it revocable? Is it voidable? I don't think so. 'Cause
Okay.
They dug this hole. I don't think the court would want something like this to be easily gotten out of.
So you're leaning towards C, no, because the assignment was for value?
I'm leaning towards D, actually.
Because all assignments are irrevocable?
No, there's no way. I can't make a blanket statement like that. You're right. C. I'm locking it in, C.
With 46% of students answering C is correct.
I
with
got there eventually.
4% of students answering D.
Ooh.
People probably reason similarly that a blanket
Yeah.
rule about how all items are irrevocable would break the
can't
the
do that.
economy.
Yeah.
In general, an assignment for value is irrevocable. Restatement second of contract section 332, an assignment for value is one made in exchange for consideration or as security for indebtedness. Here, the corporation's assignment of its accounts was made in exchange for the lender's complete discharge or the corporation's outstanding debt. Therefore, the assignment is for value and is generally irrevocable. See, the courts again are not here to make sure you get there's no
Boob defense.
Yeah, there's no boob defense. Is as Bruce Weiner, my contracts professor, would say.
Shout out,
I hear
Bruce.
I hear him. I hear him in my ear every single fucking day. The court's not there to make sure you make good business deals. They're there to enforce fairness. And this corporation received 100% of its value that the lender had not yet tried to collect is rather immaterial because now that's their property. Absent some other things like fraud or, et cetera, extenuating circumstances. So it's a pretty cut and dry question, but I think in general, it's the right one. You don't want people to be able to get out of their contracts too easily.
So I think that's 4 out of 7.
I think so.
All right.
I don't know.
Yes.
Someone in the audience tell us. I have
Please.
100% of my brain reading
Yeah,
these questions.
you're busy. And I've got 100% of my brain trying to figure out what the fuck
Between
is
us,
going
we
on.
have 0% brain. An entrepreneur hired a construction firm to build a store. The contract called for the store to be completed by April 1st. The entrepreneur believed that the store would earn a profit between $50 and $250 a day once they opened, but knew that his estimate was uncertain. In light of the difficulty of assessing lost profits due to the delay, the parties included in the contract a liquidated damages clause calling for the construction firm to pay the entrepreneur $100 a day for each day of delay past April 1st deadline. construction continued on time for several months. The entrepreneur, reasonably believing that the store would be completed by April 1st, paid a non-refundable $500 deposit for an advertisement in the local newspaper announcing the grand opening. The construction firm then encountered delays, finally completing construction on May 1st, 30 days late.
Ooh.
When the store owner opened, it earned a profit of about $5,000 per month for the first several months. If the entrepreneur sues the construction firm for breach of contract, what is the most that a court would likely award in damages? Option A, $5,500, lost profits for 1 month of delay plus the cost of advertising deposit. B, $5,000, the lost profit from 1 month delay only. C, $3,500, the amount called for under the liquidated damages clause, plus the cost of advertising deposits. $3,000, the amount called for under the liquidated damages clause.
C.
Locking in C?
I'm not even going to opine on this one. I think it's C.
Confidently saying C with 50% of students answering C. C is incorrect.
Damn it!
Answer
Well,
D,
at least-
$3,000. 42% of students answered this correctly.
Okay.
Yeah, so
Wow. Well, at least everyone else got it. Well, half of everyone else got it wrong with me.
So what's going on here is that liquidated damages is where you just sit down and say, what do we agree the damages are ahead of time?
And the advertising wasn't in the contract.
Well, no. What you were analyzing, what the trick of this question is that the question was trying to bait you into analyzing actual damages, right? Which is what we've done on this show every other time we've done a question like this. Actual damages would be stuff like the cost of the advertising, the lost months of profit, blah, 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 blah. But here, they just agreed what the recovery would be.
Yeah.
And so the court, regardless of the circumstances, is going to go for the liquidated damages. In general, liquidated damages and actual damages cannot coexist in a contract. You have to pick one, generally speaking. So if you agree on liquidated damages, you won't get actual damages.
Okay.
You can try and put both in a contract, but it generally won't be enforceable. Many business people have learned this. And liquidated damages clauses cannot be, they have to be reasonably calculated, so they can't be calculated to punish.
Okay.
They can only be reasonably calculated to make a party whole within the bounds of rationality. They're not meant to be punitive in nature. Here, parties to a contract may set the amount of damages for breach known as liquidated damages. A liquidated damages clause will be enforced if the amount is reasonable in light of the anticipated or actual loss caused by the breach. Here, liquidated damages clause appears to be reasonable. Therefore, liquidated damages controls.
Okay. I feel like I really, truly learned something here.
Yeah. This is
cool.
And this is good. You don't want a society where liquidated damage, everyone's like, if we enter into a contract and I'm like, hey, I need my podcast footage edited by next week, or you owe me $8 million. It would get out of hand really quickly across society.
Sure.
And so courts actually step in and try and stop that.
Hey, 4 out of 8, 50%.
Yes.
You know, as long as I'm not sub 50, I'll take it. I'm happy.
Hey, the pass threshold in some states is only 70 and 80%. So yeah, it's actually a pretty low threshold. Yeah. Lindsey, are you ready for your next bar exam question?
I'm ready. Let's do it.
For a hard contracts question, a painter contracted to paint a woman's house for $1,000. The reasonable value of the painter's services in performing the contract was $1,200. The painter fully performed under the contract. The finished paint job increased the value of the woman's home by $2,000. The woman breached the contract by not paying the painter. The painter sued the woman, seeking to recover restitution rather than expectation damages for his work. Is a court likely to award the painter restitution damages?
Okay, so this is restitution simply the money that was lost from the deal. Nothing else. So immediately...
I'm not telling you that.
I'm looking over help, am I right, please? So off the bat, I'm thinking it's 1,000. Boom, plain and simple. But what are my options, please?
Option A, yes, in the amount of $2,000, the amount of the benefit conferred to the woman. B, yes, in the amount of $1,200, the reasonable value of the painter's services. C, no, because the woman's only remaining duty under the contract is to pay the painter a fixed sum of money. D, no, because the party may not recover restitution damages in excess of what his expectation damages would be.
D is interesting, but I'm really not sure how to apply that. Immediately, I'm drawn to C.
C, with 44% of students answering, is correct.
Yeah,
The trap question was D, the answer was D, with 34% of students answering incorrectly no, because a party may not recover restitution damages. Typically, a non-breaching party will choose to recover expectation or reliance damages rather than restitution damages. However, restitution damages are available for a non-breaching party if the non-breaching party would have sustained a loss in the contract. Quote, his restitution interest may give him a larger recovery than would damages on the basis of expectation or reliance. However, the right to recover in restitution is limited. A non-breaching party may not recover in restitution when he has fully performed and the other party's sole remaining duty under the contract is the payment of a fixed sum.
Okay.
Yeah. Additionally, if anyone has ever seen, this is opining a little bit, but did you see that, like, there was a viral video a couple years ago of a contractor smashing up his work in a bathroom?
Ooh, I didn't see that.
Yeah, it went big on the internet for a while, in like the Daily Mail and like Talk Show Morning. Anyways, the point was a woman had paid him 50% of the contract up front. He finished the work and she refused to pay him the other 50% because the work, in her opinion, was shoddy. And then so what he did is, instead of the right thing, he went into the bathroom with a sledgehammer and destroyed all of his work. Once you finish a work like that, the work has now attached to the real property. You can't go in and then destroy it.
So he was committing property damage.
And trespass. So he went in and destroyed everything. And yes, that was his work, but it was no longer his property.
I see.
That guy got 15 months jail time.
Ooh, that's, wow.
Yeah, so what you can do is you can file what's called a mechanics lien, which is to say you can put a lien on the property. It's not actually in reference to car mechanics. It just means like a contractor's lien, basically. Was saying, you owe me this money, or he could sue. Either way, usually the construction agreement will hash out the way that would work, but there are ways to go about that. So that comes up a lot. That reminded me a lot of this question because you get people refusing to pay contractors a lot. Make sense?
5 out of 9.
5 out of 9. Lindsay, are you ready for next bar exam question?
Yes, I'm ready.
A restaurant entered into an exclusive requirement contract with a fisherman. Under the terms of the contract, the fisherman would provide the restaurant with as much salmon as the restaurant required on a weekly basis for 1 year. 3 months into the contract, a new scientific study was published showing that salmon contained dangerously high levels of mercury, causing consumer demand for salmon to plummet. The restaurant sold so few salmon dishes in the following week that it decided to stop serving salmon entirely. The restaurant informed the fisherman that it would not be purchasing any more salmon from him for the duration of the contract. The fisherman sued the restaurant for breach of contract. If the courts find the restaurant did not breach the contract, what is the best explanation? Your options are A, the lack of definitive quantity term rendered the contract too indefinite to enforce. B, the restaurant's decision to stop purchasing salmon was made in good faith. C, the lack of definitive quantity term rendered the restaurant's promise illusory. D, the restaurant had an absolute right to modify the number of salmon under the contract.
Ooh, I don't even know where to start on this one. I think it's because the restaurant has the right to say how much salmon they want. And if that amount of salmon is 0, I think that's valid. But is that breaching the contract? I don't think so.
Because remember, the question isn't did they breach the contract?
Right,
the question
if they did.
If they were ruled not to, what is the best explanation? They're not asking you to determine whether or not you actually breached it. So just keep that in mind when you're analyzing this.
I don't heckin' know if this is right, but I'm going to lock in D.
D, with 31% of students answering, is incorrect.
Damn it.
I'm sorry. Answer B, the restaurant's decision to stop purchasing salmon was made in good faith, with 52% of students answering.
Okay.
Remember that some circumstances are out of a controlling party, a contracting party's control.
Right, like the fact that people don't want salmon.
Yes, they did not pull salmon from the menu, even though they could have sold it. They pulled it from the menu because no one was buying it. Under the Uniform Commercial Code, UCC, a contract is not void for indefiniteness, even if it fails to specify a quantity term, if the contract calls for the seller to provide as many goods as the buyer requires, or for the buyer to buy as many goods as the seller can produce. The party determining the quantity is required to, quote, conduct his business in good faith and according to commercial standards of fair dealing in the trade so that his output requirements will approximate a reasonably foreseeable figure.
Yeah.
However, good faith variations from a prior requirements are permitted even when variation may be such as a result of discontinuance. Here, the restaurant and the fisherman entered into a requirement contract and the restaurant promised to buy as much salmon as required from the fishermen, the restaurant experienced a dramatic decrease in diners' demands and such needed less.
Yeah, and that's good faith. They had zero control over that.
So if you don't know the rule, a very good indicator of whether or not a question might be too overbroad is the use of absolute language. So here, D, the restaurant had an absolute right to modify the number of salmon due under the contract. In this rule, in this industry of exceptions and caveats, do you think few things are absolute?
No.
The chances are, very, very few things are absolute. So when in doubt, examine the strength of the language as that may indicate to you the right direction.
Okay.
But you did guess the second most likely answer. So
all right, well, that's something. Still 5 out of 10. You know what? As long as I don't dip below 50, I'm all right.
we're now moving into business law.
Ooh, all right.
Yes. So
switching it up.
Yeah, business law. This is going to be a lot of fun. Lindsey, are you ready for your next bar exam question?
Yes.
A restaurant. I don't know why we're fucking doing so many restaurants. A restaurant corporation had a 5-member board of directors. The restaurant wanted to purchase a plot of land across town where it could open a second location. 3 of the directors jointly owned the plot of land. The 3 director co-owners disclosed to the 2 remaining directors that they owned the land and therefore had an interest in the transaction. After these disclosures, the 3 director owners voted to purchase the land, whereas the 2 remaining directors voted against purchasing the land. The corporation purchased the land. Does the business judgment rule protect the owner's discretion to purchase?
I got no clue.
A, yes, because the 3 director owners disclosed their interest in the purchase before the board voted. B, yes, because 2 of the 5 voting directors did not have an interest in the purchase. C, no, because the purchase was conflicting interest transaction for the 3 director owners. D, no, because the purchase was not authorized by qualified directors.
Interesting. Immediately I'm drawn towards C because it wouldn't be D because let's just assume they're all qualified. It was a conflicting interest. Yeah, I think that's because they owned this property and then the business was going to buy the property from them. That seems potentially corrupt as fuck. So I'm going to lock in C.
C, with 61% of students agreeing with you, is incorrect. This was a hard question.
That was hard.
Answer D, no, because the purchase was not authorized by qualified directors.
Okay.
27% of students got this correct.
So let me guess. Is it that they're not qualified because of the conflict of interest?
Well, let's walk through the analysis.
Okay.
In general, a conflicting interest transaction is one in which a fiduciary has a meaningful incentive to act contrary to the business's best interests.
Oh.
More specifically, a conflicting interest transaction is one in which the business is a party, and 1, the fiduciary individually is also a party. 2, the fiduciary knows the transaction and knows he has a material financial interest in it. Or 3, the fiduciary knows that a related person either is a party or has a material interest in the transaction. A material financial interest is a monetary interest one could reasonably expect to impair the influence outcome of the decision. Conflicting interest transactions are not absolutely prohibited. Rather, a fiduciary may avoid liability for conflicting interest transactions if 1, the board of directors properly approves it, 2, the shareholder properly approves it, or 3, the transaction is objectively fair to the corporation. Board or shareholder approval requires that the conflicted fiduciary fully disclose all material facts known to the transaction and conflict. A majority of qualified disinterested directors or qualified disinterested shareholders with no material relationship with the conflicted fiduciary must then approve the transaction. And that's where we are. 3 of them disclosed, so they met that element. But there were still 3 of them. It was a clear majority, and the transaction went through. That means only 2 qualified voting board members participated, and therefore the transaction is not approved.
Ah, wow.
Yeah.
Okay.
Which is good.
Yes,
You don't want a cabal of financially interested individuals taking the majority of the company, and then because remember, a board is basically the committee that is the business proxy for the shareholders, particularly in publicly traded organizations. The board oversees the CEO, and the CEO acts under the direction of the board. And so what you don't want is all the shareholders in absentia basically have a board that basically lines their own pockets without any sort of recourse. Now, that being said, business judgment is a really high bar to clear. Courts do not like second guessing businessmen unless it's for reasons of like fraud or misrepresentation. Like it's something that's got to be really clear. Making a stupid decision or transaction is not that. That's why whenever you hear of all these shareholders sue Tesla or Walmart or United Healthcare. All these lawsuits are usually bullshit because it's mostly just second guessing the business decisions of the corporate executives, which is good. We should put pressure on corporate executives, but they usually are just fishing for settlements. Most of them go nowhere. The few of them that are filed, they tend to take off, but they usually are settled pretty quickly because executives don't like being in the news for this sort of stuff.
That's right. They sure
they're usually just set pieces to get a headline or to apply political pressure to the board at a crucial moment before a crucial vote or something like that. There's usually some nonsense going on behind the scenes.
Okay.
Yeah, very interesting stuff.
Goodness gracious. I'm very sad to admit that I am now at 5 out of 11.
Well, that was all the hard questions.
Oh, we're going to go easier now?
Yeah, now these are all easy business law questions.
I have a chance.
A car dealership hired a purchasing agent to represent it at all public auctions. The agent's employment contract authorized him to purchase up to 5 cars for no more than $5,000 each per auction. However, the contract was silent on indemnification. At the most recent auction, the agent successfully bid on 3 cars for $3,500 each. When the agent went to check out, the auctioneer reported that the dealership's credit card on file had expired. The auctioneer refused to hand over the car's titles until it received payment in full. The agent paid the auctioneer with his own personal credit card. Must the dealership reimburse the agent for the payments to the auctioneer? Answer A, yes, because the agent paid the auctioneer while acting under actual authority. B, yes, because the agent made the payments to the auctioneer in good faith. C, no, because the agent's employment contract was silent on indemnification. And D, no, because the agent did not seek the dealership's permission before using his personal credit card to pay the auctioneer.
So I like D and C for sure. All right. So I think no. I think it's either C or D, but I don't have any good reason why. But so is it the fact that the contract didn't have anything about indemnification? Honestly, folks, I don't really know what that means. So it comes down to, do I think that it's because the contract was silent on this part, or I don't know. Ooh, I don't know, but I think I'm just gonna throw out C. I think I'm just gonna throw it out, folks. Let's lock it in.
Locking in C.
Yeah.
With fucking 1% of students answering C. C is incorrect.
No!
With 2% of students answering D. D is incorrect. With 78% of students answering A is correct.
Oh my God, so wrong.
Generally, a principal owes duties of good faith and indemnity to an agent. Additionally, a principal must obey the express and implied terms of a contract with an agent. The duty to indemnify requires principal to compensate the agent for loss if 1, indemnification is required by the terms of the contract between the principal and the agent. 2, the agent makes a payment while acting under actual authority. 3, the agent makes a payment benefiting the principal unless the agent makes the payment officiously, subjecting the principal to a forced exchange. Or 4, the agent suffers a loss that the principal should make good in the interest of fairness, considering the nature of the agency relationship. So here, would you want to live in a world where this is how it works?
No.
Remember, look to public policy. You don't have to know the law. The law defies common sense, but sometimes it doesn't. Like,
That's true.
Just think, just think about what kind of world we would live in if people could just get out of their contracts by staying silent on this and then putting other people in danger.
If I did that, this episode would be twice as long.
That was actually a very
that was so easy.
That was a very easy question.
You
You actually got a lot closer on the hard questions than the easy ones. Lindsay, are you ready for your next bar exam question?
Let's see. That was 12. That was 5 out of 12. Shit. Yes, I'm ready. Let's go.
Ready for your next question. An investor was contemplating purchasing stock in a shoe corporation. The investor told her financial advisor that she wanted to maximize her chances of receiving a dividend if the shoe corporation paid one. Which of the following types of stock, if any, give the investor the best chance of receiving a dividend?
Oh my God, I have no clue. I don't know anything about stock.
A, par value stock. B, common stock. C, preferred stock. D, treasury stock.
I got no clue. I got nothing. Oh my gosh. I know zero about stock. So this is going to be a complete guess, folks. Based on the sound of the words treasury stock makes a lot of sense to me.
Okay. You locking in D?
Sure, why the hell not? I'm locking in D.
D, with 1% of students answering D, that is incorrect.
Damn it!
With 2% of students answering par value and 7% of students answering common stock, 91% of, actually it's less than 1%, 91% of students answered C, preferred stock, because it's preferred.
God damn it!
two main types of stock are common stock and preferred stock. Common stock often entitles a shareholder to receive periodic dividends, which are payments allocated per share for the company's profits. Common stock also generally entitles a shareholder to vote on important issues. Preferred stock usually does not carry voting rights. However, preferred stock generally offers higher priority and higher dividend returns than common stock. Moreover, preferred stock takes priority over stock when the corporation pays dividends or other distributions. In other words, if there's not enough money to pay all shareholders, the preferred shareholders receive their cut first.
Okay, at the price of not being able to be a voting board member.
Yeah, usually. There are lots of structures, but in general. Yeah.
Damn it! I'm on a losing streak here, folks.
These are really easy questions.
1%. You know what? I think it's the duration. I think it's because we've been doing this for so long now. My brain powers.
Let's see. Are you ready for your next question? You've only got two more. We can power through this.
So that was 5 out of 13. Yes. Please give me number 14.
All right, let's dive right into it. An investor purchased 3,000 shares of common stock from a car manufacturer's initial public offering. At the time, the investor's 3,000 shares represented 10% of the car manufacturer's outstanding stock. The purchase agreement granted the investor preemptive rights. 2 weeks later, the car manufacturer planned to newly issue 1,000 additional shares of common stock, which the following most accurately describes the investor's obligations, if any, regarding the newly issued stock. A, investor must purchase 10% of the newly issued stock at par value. B, the investor must purchase 10% of the newly issued stock at market price. C, the investor must purchase at least 200 shares of the newly issued stock at market price. D, the investor is not required to purchase any stock of the new issued stock.
Yeah. Why would he be required to purchase any of it?
Locking in D.
Locking in D.
D, with 91% of students answering correctly. D is correct.
Yes!
Six out of 14. Let's go.
Not a great record, folks.
A preemptive right is a shareholder's right to buy a percentage of newly issued stock equal to her current ownership percentage in the corporation, and to do so before the company offers the stock to the public. Preemptive rights enable an investor to retain percentage overall ownership in a corporation as new stock is issued. However, these rights carry a time limit and are usually not compulsory. So
Not
it's an
required.
option. Yeah, it's an option unless agreed to.
Sure.
Yeah, so there are lots of shareholder agreements that structure various situations with how the shareholders relate to each other in various situations. A person who holds preemptive rights is not required to exercise it, but may do so at their discretion.
Easy peasy.
Yeah, absolutely.
First,
Very, very easy. Honestly, that's more of a contracts question than a business law question. But
I'm learning about stock.
Yes.
For the first time in my life.
Our final question for the day. Business law question, another easy one. Lindsay, are you ready for your bar exam question?
I am ready for an easy question.
A house cleaning company hired a cleaner to serve on one of its cleaning crews. The cleaner used a company-provided vehicle to drive herself and a team of cleaners to one client's home to the next. One day, the cleaner was instructed to pick up the company vehicle from a mechanic who had just completed an oil change. The mechanic told the cleaner he would be happy to offer a 20% discount on all maintenance if the company agreed to send all its vehicles to him for service. The cleaner agreed, even though her job responsibilities did not include a negotiation contract power for the company. When the cleaner told the company about the arrangement, the company did not object because the discount would yield significant savings. The company continued to use the mechanic for the next 2 years. Does the cleaner have authority to enter the agreement with the mechanic on the company's behalf?
I don't think she does, no. But they liked it anyways. Okay, what do we got?
A, yes, because the house cleaning company knowingly accepted the benefits of the contract. B, yes, because the cleaner had actual authority to enter into the contract. C, no, because the principal may not confer authority upon an agent who has already acted. D, no, because the cleaner had no actual authority to enter into the contract.
Well, I think that she wouldn't have the authority to enter into that contract, but the business afterwards decided, sure. A, I'm locking it in.
With 81% of students answering A is correct. The trap answer here was D, no, because the cleaner had no actual authority. 30% of students answered.
Yeah.
Here, pretty fucking easy. You apparently have authority if you follow through and reap the benefits of the agreement.
If they like it, then you have been given the authority to make that decision.
So there are complicated, I'll go into the legal reasons, but first and initially, courts are set out to enforce fairness. And if in your course of dealing, you had if I had a paralegal who entered into an agreement with outside counsel to offer legal services at 80% discount somehow, even though that paralegal didn't have any contracting authority to begin with, If we followed through on it, that contract would be enforceable and authority is implied. Here we go. More legally, ratification confers authority after a purported agent has acted without it.
Ratification confers authority.
Yeah, ratification relates back to the date on which the agent purported to act on the principal's behalf. To ratify an act, a principal must manifest assent to be bound. This, in turn, requires conduct that would justify a reasonable person's conclusion that the principal consents to be bound by the agreement. A principal may expressly ratify an act with words or impliedly ratify an act with conduct. The principal's manifestation of assent does not need to be communicated to any person in particular.
Okay, there you go.
So actions have consequences.
Right. And if you follow through on something, then you followed through on it.
Yeah, fantastic. Lindsey, that is our last question for today. How are you feeling?
Folks, 7 out of 12. I mean, 15.
15.
I know how numbers work.
Hey, that's pretty close to a 50-50 split. That's pretty good for someone who didn't know what indemnification means. And that we don't tell her about these questions.
Yeah.
We don't tell her what any of this stuff means ahead of time.
What I'm doing.
I think our curve is actually increasing.
You think so?
Yeah, I hope so. It's what I choose to believe. Everybody,
Yeah, me too.
This has been Office Hours LTB with Lindsey and John. Thank you so much for joining us. Please go to our website, pledge to support our work. If we're helping you study for the bar, leave us a good review. We do deep dives every week on a legal topic or current events, and we're also doing these office hours. They're a ton of fun for us, and we hope a ton of fun for you. Also, if you want to do us a big favor, only about 50% of you who listen and interact with the show on a regular basis are subscribed. Follow us. Please follow us somewhere on socials. We post LTBE clips. We're a really new show, but we are getting a lot of traction lately, and it means the world to us if you could support us in some way. Also, big fan of reviews on Spotify and Apple Podcasts, where I think like 70% of our audience are just on those two platforms. Other than that, we'll see you very soon. Thank you so much. We hope you had fun.
Please be nice to me in the comments. I love you.